Hey guys, Andrew here, and today we're gonna talk about martial law. Now, what is that? How can we apply the legal mindset to it? What does it mean in 2020? Let's talk about it. Now, martial law is something that's been going around as a buzzword in 2020. Trump's gonna declare martial law. COVID's gonna create martial law. Biden, when he gets in, martial law, lockdown. What does that mean? Well, martial law is not something you just declare like a thumb war. It's not the laws of martial arts. It's when a government suspends certain rights through the use of the military. We often think about this in third world countries, ex-Soviet bloc countries, where you see tanks rolling in, soldiers rolling in, and they're taking control over that country. Now, what does this mean in the United States? What does this mean here in America? What would martial law look like in the United States? Well, we have some precedent. What it means in the United States is not just using the military domestically. Usually the military is used internationally. But it's not just that. It's not just the use of the military, but also the suspension of certain rights. Most importantly, the right of habeas corpus. Now, there's been several times when the military has been used domestically. For example, during the civil rights era in the 1960s, the military was used in Little Rock, Arkansas to desegregate the schools. However, martial law was not applied there because habeas corpus was not suspended. Now, martial law can be declared on several different levels. It can be declared at the national level by the legislature, at the state level by the government, or at the local level. And we have examples of all of these scenarios. For example, at the national level, martial law was declared after the bombing of Pearl Harbor by the Japanese. At the state level, it's been declared in several different instances to quell rioting and also any major work strikes, such as in New York. And on a local level, it was declared in several different instances, one of which was during the Mormon riots in Nauvoo, Illinois. Now, what would it mean for it to be declared at the national level? What does that mean, and how does the law apply to that? Well, the law applies when it comes to the suspension of habeas corpus because this is such a long-held right. Now, what does habeas corpus mean? Habeas corpus literally means of the body, the rights of the body. And what that comes down to is the right of a person to be seen before a judge when they're brought in by law enforcement. It is a protection against arbitrary arrest by law enforcement or military forces. This goes way back to the times of England when they wanted to prevent the abuses of the king. Now, here in America, we have most of our case precedent coming out of the Civil War. Now, this was a time when America was literally divided. North, South, fighting each other in a literal civil war where there was insurrections, there were spies, there were people on both sides that were undermining each specific cause. Now, what you had was Abraham Lincoln as the president in the North. Now, Abraham Lincoln is well known for doing many great things, most importantly, the Emancipation Proclamation. But what many people don't know is Abraham Lincoln actually set precedent for the executive in suspension of habeas corpus by suspending the right to be seen before a judge. Now, he did this immediately when the war first started because he was afraid that certain border states would secede and therefore Washington, D.C., which was surrounded by, for example, Maryland, would be completely within the Confederacy, completely within the South. So during the first year of the war, a Southern politician in Maryland named John Merryman took certain actions such as working with Southern militia, preventing the movement of federal troops, which blocked federal troops from moving within Maryland. Now, he was arrested under orders of Abraham Lincoln because Abraham Lincoln had delegated his authority to suspend habeas corpus to his generals. He'd allowed them to make the decision on whether or not somebody could go before a judge or not. So Mr. Merryman was taken over to a federal fort and put into federal custody. Now, John Merryman's lawyer immediately filed for a writ of habeas corpus. That is, the right to go before a judge. Now, this was actually granted because the judge ruled that Abraham Lincoln did not have the authority to suspend the writ of habeas corpus. See, Article 1 of the US Constitution clearly states that habeas corpus can only be suspended by the legislature during times of rebellion or invasion. It is very specific in that language. And Abraham Lincoln, as the president, was the head of the executive branch. He therefore lacked the authority of Congress in order to suspend that right. Therefore, the court ruled in favor of John Merryman. Now, there's a second case from the Civil War because guess what? Congress decided after the Merryman case, we're going to go ahead and authorize the suspension of habeas corpus. So we have a second case called ex parte milligan. Now, in ex parte milligan, you had several parties in Ohio that were working together to steal weapons in order to free Confederate prisoners and take over Union positions in Ohio, including a lawyer named Mr. Milligan. Now, all of them were arrested. Some of them were sentenced to be hanged. Yes, hanging was a method of execution back in the Civil War. Thank God it's not anymore. And immediately sentenced under military law. Once again, Milligan and his co-conspirators were sentenced purely by a military tribunal. They did not go before a judge. Now, what happened was these events occurred in 1863. But as always, our court system isn't exactly fast. So it took until 1866, after President Lincoln was unfortunately assassinated and his successor, President Johnson, took the presidency. Now, when this case was heard, the court ruled that a military tribunal can only exercise their powers to suspend habeas corpus in the limited purpose of quelling that insurrection or invasion, and can only do it in the limited area where it's absolutely positively necessary. Now, despite the fact that in 1863, literally half of the states were fighting the other half of the states, in Ohio, the courts were still functioning. So the Supreme Court said because the courts in Ohio, which is in the north, were still functioning, they're not a rebel state, therefore they had to bring him, Mr. Milligan, in front of the courts. And therefore, that declaration of martial law, that suspension of habeas corpus, was not legitimate. So taking all these facts together, when we look at 2020, could a president suspend habeas corpus? Probably not, based on that precedent. Could they enforce martial law? Unless there was a huge incident or insurrection, they would not be able to do that. And even if they did, it would probably be limited to the specific area where that insurrection was going on, because under Milligan, you've got to apply it as narrowly as possible. So once again, martial law is not something we worry about in the United States and not something we're likely to see here, thankfully, because of the US Constitution. Now, if you like this video, please like, comment, subscribe. Feel free to leave any comments below if you'd like to see certain topics in the future. But until next time, this episode is adjourned.